Namaste. We have breaking news on the MC Singla case, which is now listed for an interlocutory hearing on December 10, 2025. I am Priya Chakraborty and my co-host is Anil Agarwal. Today, our mission is twofold. One, to carry out a deep analysis of the interlocutory application made on November 18 by Council following a brief appearance at the Supreme Court, and two, to correct the inaccurate interpretation of the coming December hearing made by the media, etc.
To understand the interlocutory application or IA for expedited listing in MC Singla Visas, Union of India, SLP C, number 55561, 2016, one must look beyond the mere administrative act of scheduling. It represents a collision between the doctrine of substantive justice and the administrative reality of the Supreme Court's docket explosion or backlog.
Okay, let's get into it.
Yeah, let's do that.
For our listeners who might follow litigation but aren't deep experts in Indian judicial law, what exactly is an interlocutory application in this context? It sounds like fancy legal stationery?
Yeah, it does. But it's really the formal way a party gets to speak to the court while the main fight is still going on. So, think of the main case, what lawyers call the lis pendens, or the main story.
The IA is a necessary side conversation. It's a plea you file while the main suit is still pending, and it's asking for some kind of relief that's ancillary or secondary to the final judgment you're hoping to get.
So if the main case is asking the big question, should I get pay parity? The IA is a sidebar, asking the much more urgent question, can you please hear my main case now?
Precisely. You've hit the nail on the head. The IA is the specific tool, the vehicle you use to talk to the court when your case isn't on the daily list or schedule.
Okay, so if you need to file more documents, ask for a stay, or, like in MC Singla, you want to ask for an expedited listing or early hearing, you file an IA.
It's a procedural tool, but it sounds like it has massive strategic implications.
Oh, absolutely. The implication here is trying to bypass a queue that's held their case hostage since 2016.
Yes, in the architecture of Indian litigation, an interlocutory application is a plea filed while the main suit, the lis pendens, is still ongoing. It seeks relief that is ancillary to the main judgment. In the context of the Supreme Court of India, the IA is the vehicle used to speak to the court when the case is not currently being heard on the bench. The relief sought in this specific instance is expedited listing or early hearing.
And this isn't just any IA. This one was filed in the Supreme Court of India in the case of MC Singla versus the Union of India. Now, this is a big case, a special leave petition that was first filed, believe it or not, way back in 2016. And as we've already implied, this isn't some tedious legal exercise. It's the procedural equivalent of a high-pitched scream from litigants.
To understand the intent of the IA, one must appreciate the essence of the underlying dispute and the context of the MC Singla case. Taking the subject matter first, TMC Singla is a seminal service law matter. It generally pertained to issues of pay parity, pensionary benefits, and historical injustice regarding government employees, specifically relating to the disparity between the central government employees and public sector autonomous bodies like banks, railways, tailways, etc.
The other context to this case is the timeline. The special leave petition at the Supreme Court was filed in 2016. We are looking at a pendency or holdback of nearly 9 years. In the life of a civil servant, 8 years is a massive epoch. It covers promotions, retirements, and sometimes mortality. Indeed, the original litigant, Mr. MC Singla, is deceased.
In this context, when a council files an IA for expedited listing in a service matter like this, they are effectively petitioning the Chief Justice of India, the master of the roster, or the presiding bench to bypass the computerized listing system.
The Supreme Court has thousands of cases in the queue. A case from 2016 in the ordinary course might sit in the regular hearing category for years. This IA is a plea asserting that the queue itself is an injustice to the litigants or retirees. But in case you're thinking this application is unique, well, it isn't. Drawing upon the records of the registry and the procedural history of MC Singla, the short answer is IAs have been filed before at various other times.
And the tension right there, that's what we'll unpack. This IA, it's not about just moving a file from one pile to another. It represents a fundamental collision. On one hand, you have the immovable object, which is the Supreme Court's massive exploding docket, just slamming into this irresistible force, which is the doctrine of substantive justice.
Therefore, this is justice delayed is justice denied. Screaming from the chhat ke upar, the sound of 8 years of waiting. It's the litigants finally demanding to be heard. Again. From a jurisprudential standpoint, the intent behind filing this IA rests on 3 pillars.
Pillar 1, the doctrine of infructuousness or fruitlessness. In service jurisprudence, time is the essence of the remedy. If the petitioners are retired employees seeking pay parity or pension adjustments, the delay creates a risk that the relief, even if granted, becomes useless due to the death or extreme old age of the petitioners. The intent of the IA is to prevent the judgment from becoming a paper decree with no living beneficiary.
So, Pillar 1, the doctrine of infructuousness. That's a mouthful. What does that actually mean in the context of the IA?
Yeah, it sounds technical, but the idea is actually very simple. Infructuousness just means fruitless. It means the judgment becomes pointless. It has no real world effect. In service law, well, especially with pensions and pay, the money, the relief, is tied to the life of the person who is supposed to receive it.
Can you give us a concrete example of what becomes fruitless or infructuous?
Sure. Imagine a retiree who's been waiting 8 years for a ruling that their pay scale should have been higher all along. That directly affects how their pension is calculated. Now, if that person passes away before the court rules, it becomes a hollow victory, a paper exercise.
Pillar 2. Got it. The constitutional importance or Article 21. While MC Singla is a civil service dispute, the delay invokes Article 21 of the Constitution, right to life. The Supreme Court has held in various precedents, Ingaji Husainara Khatun, that speedy justice is a fundamental right and is therefore part of Article 21. The IA argues that the economic livelihood of the pensioners is a facet of their right to life, necessitating an urgent hearing.
Pillar 3. C. Settling the question of law or stare decisis, MC Singla is likely a lead matter or is tagged with other similar petitions. When an IA for early hearing is filed in such a case, the intent is often to unclog the judicial system. By deciding this one case, the court could potentially dispose of dozens or hundreds of connected matters pending in high courts or tribunals across India. The intent is to establish res judicata or finality on the specific point of pay parity.
Crucially, the judicial test for granting the IA before it is placed before the honorable judges requires specific criteria as per Supreme Court Rules 2013 and established convention to be met. MC Singer satisfies 3 of these litmus tests.
Number 1, senior citizen status. Are the petitioners over 65 or 70? This is common in MC Singla type cases. Number 2, stay orders. Is there a stay order operating that is paralyzing the government department? Number 3, covered matters. Is the issue already covered by a recent Constitution bench judgment? Delhi, Jaipur and Chandigarh judgments are prime examples.
Against this background, the IA for expedited listing in MC Singla is not merely a request for a date. It is a formal assertion that the delay has become prejudicial to the substantive rights of the litigants.
It is an attempt to persuade the Supreme Court that while the wheels of justice grind slow, in this specific instance, they are grinding too slow to deliver equity to a class of government servants who are literally running out of time, just as Mr. MC Singla and many bank retirees and elders of India's banking have done. Ran out of time.
Therefore, this interlocutory application is the vanguard of a high-stakes legal and constitutional arguments the long-suffering litigants are using to try and force the Supreme Court to grant an early final hearing.
So if a petitioner or retiree is already 60 when the case starts, 8 years later, they're 68. They are deep into their senior citizen years. For many of them, the fear is that a decision will simply come too late.
Which is why they can't just wait in line, Because if they wait, the victory, even if they get it, becomes almost meaningless. Because if you understand this one point, you really start to understand the pressure points of the entire judicial system.
It's become a substantive injustice. They're saying this delay is different, it's uniquely harmful to us, and you have to treat us differently.
Exactly. Moreover, a ruling here could set a precedent for the entire structure of government service, its hierarchy, its benefits. And when you factor in that this petition has been pending for over 8 years, the delay itself becomes the main opponent, not just the other side.
They're arguing that a systemic delay that destroys a person's economic dignity is a violation of the same constitutional protection. It elevates this whole thing far beyond just in interpreting a service rule. So, by deciding MC Singla, the Supreme Court creates what they call res judicata, finality.
Precisely. Argument is, look, if you just hear our case now and settle this legal question once and for all, you will immediately unclog hundreds of other cases. You'll stop this endless cycle of litigation that's eating up time in high courts and tribunals everywhere. It's an appeal that says, help us. And in doing so, you help the entire system.
It's such a powerful combination of arguments. You have individual suffering, a constitutional command, and systemic efficiency.
That's the strategic brilliance of it. It gives the court every possible reason to feel compelled to step in.
And since the court has already formalized the idea that life expectancy is a factor in delivering justice.
Yes, and clearly, a case like MC Singla, filled with petitioners in that demographic, is a lock.
It seems like this whole process, this EA, is about finding that gap between the administration of justice and the substance of justice. It's about convincing the court that the very procedure designed to manage the flow of cases is, in this one instance, causing a direct violation of human rights.
That is the perfect way to put it. IA is not a routine request. It's a carefully built argument that the delay itself has become prejudicial, that at this point, judicial inaction is the same as judicial harm. They're asking the Chief Justice to admit that the normal slow grinding of the wheels of justice is, for them, simply too slow to deliver any real equity.
It really makes you appreciate that procedural justice isn't some secondary issue in a system that's facing a docket catastrophe. Procedure is the battlefield.
It is. It's where constitutional rights are either won or lost long before a final judgment is ever written. The decision on the IA can be the whole ballgame.
So we focus today on the service law side of this, on the pay parity and the pensioners in MC Singla. But for you, the listener, here's a final provocative thought to take away. The fact that an IA like this is even necessary shows the incredible administrative pressure the Supreme Court is under.
We know the Chief Justice is the master of the roster. Now, if the docket explosion forces this level of procedural emergency for a group of senior civil servants, what kind of pressure does that role put on the Chief Justice when deciding what gets heard first in other critical areas, like urgent challenges to new laws or criminal appeals, where someone's liberty is hanging in the balance?
That wider implication of how the court manages its time, that is the next and maybe bigger conversation. The burden of that office is administrative, it's legal, and at the end of the day, it's deeply, deeply human.
We trust that more than simplistically stating the next MC Singla hearing is on December 10, our dissection of the inner workings of interlocutory application has given you food for thought and a better understanding of the Indian judiciary.
After all, the more understanding you have of how India's judiciary works, the more likely you are to make a judgment on the veracity of the information you consume via the press or social media.
And that's a wrap for today. Please like, comment, subscribe and share this podcast, thus ensuring more elders and their families have access to our quality podcasts. Bye for now.